Dear President, dear colleagues, dear present and still persevering, persistent participants, which also shows that you are very dedicated stakeholders of whatever we call children's rights. Please allow me to start out with a picture which to me is a determining moment, and several determining moments 12 years ago when for the first time I visited the African continent, and I had the opportunity to experience the huge gap between the European, Hungarian, and the world outside Europe, especially certain African countries. The national and ethnical differences. In the picture we can see children I met on the way. We discussed, we exchanged ideas, and to me honestly said, so I usually quite sensitive in terms of vulnerable people. It's not by accident that apart from my official university tasks, I am also Vice Commissioner for Fundamental Rights. Based on the request of the organizers, I wish to speak a little bit about the right to education of children belonging to nationality and minority groups. Of course, these will only be some impressions that I have, and as the institution and the legal framework, hard law and soft law available for this purpose is surely not unknown to the people present here. So I would skip this one. It's basically a list of the documents of the different children belonging to different nationality and minority groups, and the rights of the different nationality and minority groups. Listing these already would take more than 15 minutes. So I would like to concentrate on three things, only short impressions. So I would like so I was a member of the group elaborating the Minority Framework Agreement, and I could see that the rights of the children, and that the children are entitled to based on the Framework Agreement. What is it that the national states wish and do not wish to guarantee in terms of education of minority groups? The other one is the FUEN and its survey, latest survey of 2021. This international body carried out a survey in 2020 which offers a different perspective. The Council of Europe wishes to present a professional expert, prepared by independent specialists based on fieldwork. FUEN, however, turned the question around, and it is the communities themselves that were asked whether the fundamental rights that the minority groups are entitled to in different groups, in different countries, to what picture does this provide to them based on their experience, based on their impressions? And it's on this basis that I would like to draw certain conclusions. And of course, it goes without saying that we also need to see what is the concrete situation in terms of the education of nationality group children. If you believe that this is mission impossible because the title is promising, but it is basically impossible because it says international and national experience. If we only had the experience that we could sum up in 15 minutes, then we would do an awful work. So as for the framework agreement, and I would like to apologize from the interpreters, but I will not translate these texts every now and then, so I would only like to highlight that the Minority Framework Agreement, which which has the biggest number of signatories. In its article number 12, basically on the territory of signatory states, it in a direct or indirect way provides for rules in terms of children belonging to nationality groups. This is a framework agreement. I would only like to call your attention to paragraph 3, which says that the signatory states undertake to promote equal opportunities for access to education at all levels for persons belonging to national minorities. Other extra undertakings are the ones are in national competence. So if they wish to provide for more, if we take a look at the Hungarian Constitution and the Hungarian Act on National Groups, if we take a look at the rules in terms of national education, which we do not always like, of course, then this shows that indeed national legislation goes a lot deeper than whatever the framework agreement expects in this regard. As for the framework agreement, it accepts country reports, and professional positions are being drafted on this basis, and as a consequence of this, we can categorize the different questions and problems that this counseling body notices in certain countries. And we can categorize this in 3 groups independently of what state we are talking about. Of course, performing, executing these, then the level of execution is also different in each and every member state. And as I always also wanted to say at the beginning, but I forgot at the beginning, I wish to say that national and minority groups, so nationalities, are given educational rights, and the children belonging to national groups who are the beneficiaries of these rights, well, all these live in a multidimensional reality. And as a Pavlovian reflex, we always try to simplify each and every situation of life. We are not entitled to do that, not even as jurists. We need to look behind the rule to be applied. Commissioner of Human Rights, the function of Commissioner of Human Rights entitles us to examine this, and it is also our obligation. Of course, the international position and opinion which this counseling body also represents, and which categorizes 3 different larger groups in terms of the problematic revealed situation. First of all would be schooling. Different schooling rules and regulations in different states. School attendance, that is access to education, and different items, different elements which to a different degree are present, which have to be handled either by the state centrally or locally by smaller settlements in order to provide for reaching a larger settlement in order to provide schooling there, or guaranteeing how to convince parents and how to keep parents in a situation where they can ensure, even if they live in a seriously disadvantaged circumstances, that their children are guaranteed education in the best possible way. And of course, the given signatory state has to go against, well, has to help actually, the family, this family intention. So so we can see very good comparative analysis here. So please do dive into these recommendations deeply. We are already beyond the 5th monitoring cycle in terms of the framework agreement. if it comes to the original signatory states. And the third one will be something that I will provide a typical Hungarian example as well. And the third would be success, school attainments. What is it that we achieved? How successful, how efficient is the different kind of education? What do we have to do if so which state reacts how to different kinds of school absenteeism? What do we do if early dropout rates are really high among children? How does the state react to this? What aspect does it have in terms of acceptance in school institutions, belonging to different ages, to different sexes, if these children belong to certain national groups and they need to be highly protected or more protected? So as said, I would only like to highlight certain facts, and I'm trying to convey feelings, emotions as well, but based on the facts. Here we can see this survey carried out by FUEN back in 2020. FUEN is roughly has member organizations. They reached out to 58 minority groups, national groups, and based on the opinion of hundreds of minority people, they came up with their report, which identified several difficulties, several challenges, to use a polite word, a polite term, behind which we can see problems, different situations of life, and also situations to be solved which do not require either too much money, but a lot of intentions from the affected community, institutions, and states. Just a short list of the deficiencies that were able to be identified. Of course, in such short time, it is difficult to explain that not in each and every member state is there a lack of the preservation of minority culture and language, or that there would not be a lack of teachers training, but in some cases this is indeed not provided for or inadequate, or something that occurred in the recent past. In the past 2 years, based on the world pandemic and due to the events happening in our neighborhood, the voices which say that we need to adapt new methods in terms of education are stronger now, or that new methods have to be let in. And these slides, of course, will be made accessible should anybody be interested. Minorities in Hungary, and I'm already panicking because I can already see that the chair is signaling that my presentation is coming to an end. Hungary is very generous and allocates a lot of budget in terms of promoting nationality education. There are infographics which also show that there are more than 230 educational institutions in Hungary sustained by minority local governments with a special status. Just take a look at the two columns on the left. 13 endemic nationalities exist in Hungary, and the Roma and the German communities are the ones who could make use of the full spectrum the Constitution provides for, and the Act on Nationalities adjusts even further, fine-tunes even further. So the individual and the collective rights that are provided for to the nationalities and logically to the children as well, with the help of the legislative background. So the use of the mother tongue, education in the mother tongue, which is also an individual and a community right, and as a community right, the creation and sustaining education and cultural institutions. What do we see in the society? We look at it from bottom up. So we take individual complaints, and what I can share with you is basically that this generous legislative background and the extraordinary budget allocation, in spite of this extraordinary budget, where do we run short? Where do we have problems? And of course, the complaints that reach us is in accordance with the share of the nationalities in the among nationalities. So most of our problems highlight structural problems, and here I am talking mostly about the Roma community, because it is not unknown to you, dear colleagues sitting here in the room, that the Roma community, in the case of the Roma community, it is not only about making use or not making use of the opportunity to receive education, but that the principle of equal treatment has to be understood here as well. And what is an unfortunate phenomenon, not only in Hungary, because later on we will also talk about what other problems arose in front of courts and international fora. But what I can tell you from my personal experience is, for instance, in terms of education, authentic content has to be shown, has to be conveyed in the framework of educational material. And these are deficient, my experience tells me. Among others, we cannot see, for instance, when teaching about the Holocaust, that that the Roma community also suffered a lot in this age. The Council of Europe also provided help in this regard. In the spring of 2020, a study was carried out, and we also showed that this would be an issue which is not included. It's not even part of the knowledge teachers have at disposal. I believe I'm already beyond my 15 minutes. In 2020, when we took a look at the effect of the pandemic on the Roma community, a huge part of this consisted of the examination of transition to online education and what disadvantage, what drawback this meant to the Roma community, which already is hugely disadvantaged, especially the institutions where Roma children have a larger share. And of course, among theoretical positions, there are three subjects which would be more comprehensive. And we drafted these positions, we published these professional opinions, three subjects. One is educational segregation, which is unfortunately continuously present, and only in the long term and only in a very difficult way and only in a holistic way can it be solved. Only together. This is how it can be handled, treated, managed. This is how we can achieve results. As said once more, in the long term, but for this we need the proper intention. The word gyöngyös. Well, there are places which are hard to pronounce, hard to say, but my task is to talk about such things. We checked in a 10-year perspective there was educational segregation in Gyöngyöspata, and we checked what changes happened in Gyöngyöspata along a 10-year period, and unfortunately our conclusion was that in the given settlement, in the given school, there is not one single Roma child in that school. When all this situation came about more than 10 years ago, this was an artificial discrimination. It was illegal differentiation, as the court also found. However, the situation back then achieved that there is a so-called spontaneous segregation currently in the settlement. So the non-Roma children are taken to other settlements in the neighboring schools. So at kindergarten level, children are not only integrated but also inclusive. This is how they attend. And we actually do not comprehend, we do not perceive, well actually we perceive, but we do not wish to accept that the moment that the children enter school itself, the non-Roma kids are taken somewhere else. The teachers who still stayed in that school are in a terribly difficult situation, but that's what it is. And the two other subjects, only very briefly, one would be our theoretical opinion 1/2021, which is about children belonging to minority groups very often have behavior and integration problems. The social network of institutions whose task is to monitor them, to provide a follow-up to them in spite of the laws, show that there are gaps. They expect very often from the parent an activity which cannot be expected. Institutions should create a flawless, a gap-free collaboration in order for the continuous education of the child not to be broken. And third would be school absenteeism, which actually shows that the current regulatory background punishes absenteeism with sanctions which I am convinced do not serve the child's purpose, because the child starts with a sanction. If family support is withdrawn just because a child, for whatever reason, did not spend a given number of classes in school, and if this is not paid, then the family father will be locked up. And what will happen to the child in this regard? So it is in these questions that we tried to call the attention of all the decision takers and important stakeholders. And as my time is up, this is what I expected that would happen, that my time would be up. So with the help of the QR code, you can download this bulletin, and you will be able to access all the comprehensive text summary, both in English and Hungarian. These are available from 2021. It would honor me if you took a look at this. And if you, and also if you write to me your opinion. And it is with this that we try to call the attention of the children and parents what the Vice Commissioner for Fundamental Rights is good for if a national group or minority group is involved. And thank you very much for your attention.
Az első gondolatom, elnézést, hogy rögtön ki is jöttem, csak hogy így egyszerűbb volt. Az első gondolatom egy...
So my first thought is congratulations. Now that we are all here today in the framework of a two-day international conference, it's something really special and unique. And I do hope that this won't be the last such possibility, but rather the opening of regular meetings together. So once again, congratulations to the Ferenc Mádl Institute of Comparative Law and Marta Benyus especially, who has been working on organizing this conference over the past weeks. And also thank you very much for the possibility that I can be here and talk about the child's right to health, self-determination. And actually, it's also about the guardians of children, and I will talk about the practice and all the current aspects of this topic. What do we actually mean by the right to self-determination of the child? It's whether they can decide if they want access to healthcare, whether they can accept or refuse a medical treatment or intervention, the right on information, all legal sources, be them Hungarian or international. They say that children have to be informed, so they have a right to information. They also have to be involved in making decisions in this respect. And also another very interesting domain is the medical confidentiality area or other health information, but I won't have time to talk about this today. So, but this whole area also includes this kind of right of the child. So what if, for example, medical confidentiality shall be practiced as opposed to the parents. So the child would want to keep certain things confidential and secret before the parents. However, today I would like to highlight two specific areas. So concerning concrete provisions and mandatory vaccinations, on these two topics I would like to concentrate on today, and also the court practices and jurisprudence. Unfortunately, I won't have time to talk about the Hungarian legislative background in details, so just a few notions to this. There is a fundamental law, there is a Family Protection Act, a civil code, about there are provisions concerning the capacity to act, the capacity to make declarations by children. This is also in compliance with the Act on Healthcare. So the civil code makes differences concerning legal declarations between those who have the capacity to act and those who do not. It's still a main rule, a sum of rule, that there is a same regulation up to a certain decision by a constitutional court concerning minors. So when this kind of decision came by the Constitutional Court, 32 per 2000, this decision by the Constitutional Court about the need for more differentiated regulation, it states that in order to be able to make a decision concerning a medical intervention, the rights should differ in the case of a minor aged 3 years or a minor aged 17 years. So differentiation is necessary. So this is why in the year 2002 there was an amendment of the Penal Code on the 1st of January. So different rules apply since then for mature minors over 16 years old. But this is still not enough. Even more differentiation would be necessary. So at present, children above the age of 16, so a so-called mature child, can actually refuse to make use of his right to giving declarations. So now we are talking about illnesses. What is interesting that if a child is above the age of 16, then he has the right to appoint a person that on behalf of him to exercise his right on acceptance or refusal, a medical intervention that he should undergo. But this he has to do in a notarial deed. So this is for those above the age of 16. So in a given situation, he can appoint somebody, an adult different from his or her parent. Maybe it's a doctor, so who can in this way make a decision on his behalf concerning a medical intervention. An exception makes abortion. So in that case, the parents' consent is definitely necessary. Now, concerning the Act on Healthcare Law, concerning invasive interventions, there is a written consent necessary, so this applies. So the child can be examined and given medication without the parents' consent too. So the law is quite clear about this. It's the parents' decision or the guardian's decision cannot be disadvantageous to the health of the child. This means that the interest of the child should always be considered as primary. So no, nothing. This kind of intervention must not lead to any kind of serious or permanent damage to the child's health. Now, if, for example, a parent says no to an invasive intervention, which would be necessary in the interest of the healing of the child, then even if the parent says no concerning this operation and invasive intervention, it has to be carried out because that's the interest of the child. And now I would like to talk about the vaccinations, which is to be seen as an invasive intervention, though there are some exemptions if there are just little risks. But in the case of vaccinations, literacy states that these are invasive interventions, so this is why the guardian's consent is necessary for this, and before that, of course, information provided. Now, this only so in the case of optional vaccinations. In the case of the mandatory vaccination, the consent of the parent is not necessary, and many parents have problem with this. Actually, there is a procedural order concerning mandatory vaccines. In Hungary, we have this system of medical caretakers for mothers and for the children. It's really something special in Hungary that we have. And one of her duties is to register mandatory vaccinations and to give information about these to the parents and informing parents and telling them, notifying them to ensure that the children be vaccinated. So until school age, it's the children's doctor who administers these mandatory vaccinations. Above that, it's the school doctor. If even though there were written notifications 3 times and the parents still refuse the administration of the vaccination, then it becomes really mandatory, and then it's compulsory. There is an appointed time and place where the child has to emerge and go and has to undergo this vaccination. So there was this decision by the Constitutional Court in 2007, which is really important because it's been quoted ever since. And this decision stated, well, one is that the vaccination can be considered an invasive health intervention for public health, epidemiological purposes. It further held that the legislation institutionalizing compulsory vaccination and laying down the conditions for its use constitutes a restriction of the right to bodily integrity. So it's necessary. It cannot be considered an unnecessary restriction of fundamental rights. So it's good for the whole. It's a compulsory vaccination is a suitable necessary means of ensuring the proper physical, mental, and moral development of children on the one hand, and protecting society as a whole against infectious diseases and epidemics on the other. However, a serious legal dispute has arisen over the immediate enforceability of the health authorities' decision to order vaccination, with the Supreme Court ruling that the establishment of active or passive protection against communicable diseases is in the public interest, justifying immediate enforcement. Actually, it has to be stated that all mandatory vaccination is free of charge in Hungary. So what is the problem? Already in 2008, the European Parliament issued a resolution that delaying mandatory vaccines or refusing them has reached really alarming proportions. The main arguments concerning the denial of vaccination are the following. Well, first, the people's freedoms against the state. So in these protests, we rather hear that nobody should tell me that what I should do, whether I should bring my child to be vaccinated. So very often parents have a problem and they resist this kind of mandatory obligation. And sometimes the argument is that they fear that vaccinations have harm on the health of their child, or that they are not effective. So those doubting vaccines are on the rise. Before COVID, there have been already many issues, many problems, and this is how I try to find a structure for you to see what have been the arguments of parents against compulsory vaccination. Well, one argument was freedom of education, the right to privacy, the right to freedom of choice, that they are unwilling to accept that somebody else imposes such things on them. And then the Supreme Court had a clear resolution on this issue. The Supreme Court said that it's irresponsible from the parents not to consent to the administering of such mandatory vaccination. So first, the child itself should get this protection against infectious illnesses, and then herd immunity is also very important. So the more people are vaccinated, the more the possibilities that this infectious illness will extinct. So it's the right to self-determination. So that was the one reason. And then the second argument was the inviolability of the next one was the physical integrity, health right to physical integrity, quoted by children. So many people say and believe that vaccines themselves are very harmful and are to be feared. The literature says that those illnesses for which we have these mandatory vaccines, well, the majority of the population does not even go through these illnesses. So this is why the people are not aware how serious these illnesses can be, because they are not really present anymore due to vaccination. So this is why now the consequences of the vaccines are being rather in the focus and not the infectious illnesses themselves. Of course, this is a misconception in the case of mandatory vaccinations that the state has an obligation to pay if really something harmful to health happens as a consequence of mandatory vaccines. So this right to physical integrity really says that such vaccines might really infringe on physical integrity. However, if we look at the proportionality, then according to Supreme Court decision, it says that the public interest takes precedence over the right to bodily integrity. And now really very, just a few thoughts about the sanctions. There exist. If should the parent refuse the vaccination of their children, at present there is a health fine, a quite high fine from 30,000 forints to up to 5 million forints to be paid. There was an investigation by the ombudsman how effective such health fines are, because wealthier parents might have no problem with paying this fine, and in this way the more unvaccinated children would threaten the safe herd immunity. And another possibility for sanction was that, but this is only a question mark, as at the age of children, kindergarten children or nursery age children. So there is a report by the Ombudsman from 2016. So this refusal to enroll in kindergarten, it's no sanction applicable at present. Also, those children who are not vaccinated have to be accepted by the kindergartens or the nurseries. Now, this is very interesting because there was a case by parents in the Czech Republic that says, so the European Court of Human Rights has ruled against a number of parents in the Czech Republic who complained that the authorities had fined them for refusing to vaccinate their children, and the nursery schools had refused to admit them on the grounds of a lack of human rights violations. There's something else, that there was also a criminal case lodged against the parents who regularly refused vaccination to the child, and actually also hit the child before the authorities. But the court said that the herd immunity is so huge in Hungary itself that even if the child is not being vaccinated, it does not have direct negative influence and harm to the public, to the society. So actually, those parents who do not allow vaccination of their children can think that they cannot be put to court because such large majority of children and people are vaccinated in Hungary. So that's a bit bizarre. And then next thing, that those guardianships, so concerning guardianship, so if the guardian refused the vaccination of the child, then the child was removed from that family for vaccination and then was given back to them. So concerning those parents who hide their children or refuse their children, that is so this is unproportional legal limitation. And now what I also want to highlight is that this mandatory vaccination doesn't mean that everybody, even if irrespective of anything, has to be vaccinated, because of course the law gives the possibility to postpone a vaccination for health reason or or exempt them for health reasons. But what is interesting, there are really many cases of such exemptions because parents who are against vaccinations really count on this possibility given provided by law. So it's again what is necessary, what is proportional. This has to be always investigated. So at present, what could be a solution that the parents say that they have a right to choose their own doctors and then they will organize, so to say, vaccination. But this has also led to many problems, especially when, for example, a doctor who was of Austrian nationality practicing in Graz, from him a certificate about vaccination was asked for, but it turned out that it was a false vaccination certificate, and that's a criminal offense, and this was not the only case. So then there was the pressure from the parents resulted in false vaccination certificates. In the Constitutional Court really had really harsh decisions in 2022. So there were resolutions concerning the administering of the vaccination, and if it was not carried out in the adequate way, then the vaccination had to be re-administered. And the Supreme Court also approved this resolution. However, we have a decision now by the Supreme Court that turns this whole thing around from 2021 that says that it has to be investigated whether the protection is there as a result of the vaccination, and if a blood test really proves that even if the vaccination was not carried out adequately, but still the vaccination is effective and protection is there, then it is also okay. So a re-vaccination of a child would maybe cause an even bigger risk if the blood test says that the original vaccination had its effect. So then the blood test has priority over the circumstances of administering the vaccination. There are definitely parents refusing mandatory vaccinations for different reasons, but one thing is clear, that this respect we had very strict regulations in Hungary, and revaccination could be ordered by the health authority even, so the case could even reach this stage. However, one thing is for sure that for all of us, should be important that there should be secure mandatory vaccinations with adequate procedures, and we really do hope that such mandatory vaccinations the regulation around them will remain as they are, because we can say that in Hungary we are very successful concerning the administering of mandatory vaccinations. So we have a very high rate of vaccinated people. Thank you very much for your attention.
Köszönöm szépen a felkonferálást, és elnézést kérek a magyar ajkú résztvevőktől. A magyar nyelv minden csodája ellenére angolul fogok előadni. All right, ladies and gentlemen, first of all, I would like to express my gratitude for the invitation. It is an incredible honor for me to be able to talk about this topic so near and dear to my heart. My name is Lilla Garayová. I'm the Vice Dean of the Pan-European University in Bratislava, and I'm an Associate Professor of International Law, as well as a researcher of the Central European Professors Network. And today I'm going to talk about the children's right to play. So, oh, it was child's play, or gyerekjáték. We often say very dismissively in many languages when we talk about a task that is way too easy to accomplish. But is child's play merely that? I don't think so. Deeper research on children's rights opens up a field of unsuspected width and depth and importance, not only for the child's personal development, but also for the development of the community. Through this research, through play, children learn, and they learn how to participate in the community, and they adopt rules and the system of values that the society which we live and learn. So in literature on human rights, we find that the most important thing is to teach for human rights, and that means to develop the sense of self-respect and respect for others, and acceptance and understanding for emotions and needs of others. And children develop these rights and these features precisely through play. So play is incredibly important, and be more specific, through spontaneous and unstructured play in early childhood. And what is play? Different definitions on play can be found in literature. And that is understandable, because to find a unique definition on something so complex as play is not easy at all. However, the authors of these definitions agree on some specific characteristics on play. Ozan and Ozan says that play is often defined by comparing it with what it is not. Play does not involve work, it is not realistic, it is not serious, and it is not productive. Margaret Kiernan draws on the definition on play given by the National Playing Fields Association and the Children's Play Council from the year 2000 that says, children's play is freely chosen, personally directed behavior motivated from within by needs, wants, and desires. By playing, children learn and develop as individuals and as members of community. Lester and Russell suggest that play is a behavior that is distinguished by specific features that represent a unique way of being, a way of perceiving, feeling, and acting in the world. The act of playing, where children appropriate time and space for their own needs and desires, has value for developing a range of flexible and adaptable responses of the environment. Or, as in the words of Fred Rogers, play is often talked about as if it were a relief from serious learning, but for children, play is serious learning. So all of these definitions suggest certain features of play. They tell us what play is and what it isn't, and all of them pose the following question: what is so specific about play that it was necessary to define it as an inalienable, indivisible, and universal right of the child? So the conceptualization of play as the child's right is guaranteed by the Convention on the Rights of the Child in its Article 31, which states that every child has the right to rest and leisure, to engage in play and recreational activities appropriate to the age of the child, and to participate freely in cultural life and the arts. So the right to play, nevertheless, is widely regarded as a forgotten right. Despite it being over 30 years since the Convention on the Rights of the child's right to play has so far been extremely undervalued and overlooked in children's rights literature and also in practice. So, nevertheless, extensive research shows that play is crucial for the child's development. The historic lack of engagement with the right to play has led to its very poor implementation and the protection of the right, which prevents children from enjoying this human right fully. So concerns that the obligations arising from Article 31 of the Convention, essentially that these rights were not being addressed by the governments, prompted advocacy by the International Play Association, and ultimately this led to the publication of General Comment number 17 on the right of the child to rest, leisure, play, recreational activities, cultural life, and the arts. So essentially, this elaborates on the right of every child to play, as well as identifying different risk groups, including girls, including children living in poverty, children with disabilities, children from indigenous or minority communities. So the general comment defines play as behavior initiated, controlled, and structured by children, as non-compulsory, driven by intrinsic motivation, and that it has key characteristics of fun, uncertainty, challenge, flexibility, and non-productivity. So children regard playing as one of the most important aspects of their lives and value the time, freedom, and places to play. So the importance of play for children is physical, emotional, social, and intellectual well-being and health has been well researched and documented. So some of these benefits occur immediately as children play, while others develop over time. And the intertwined benefits of play relate to the intrinsic value, entertainment, enjoyment, freedom, while instrumental value as well, which is education and development. So key characteristics of play, including uncertainty and challenge and flexibility, influence the children's ability to adapt, to strive, to survive, and to be resilient, and it shapes their social environments. So through play, children can experience a range of emotions, including frustration, determination, including confidence, and through practice they can learn to deal with these feelings and emotions. So the importance of children being able to play without intrusive adult controls or structure has been recognized as an important factor in promoting lifelong attributes such as resilience and flexibility and the development and maintenance of children's social relationships. So despite the evidence benefits for children, including older children, there are many temporal, spatial, and psychological factors that limit children's access to play. And in recent times, opportunities to play, as defined by General Comment number 17, have been diminishing and have been affected by factors such as increased traffic, such as the social media, such as closure of play facilities or educational pressures and parental anxieties about safety, or in the past years, the pandemic, for example, or in the current year that we are talking about, humanitarian or military conflict. Of course, all of these affect children immensely. So within the family, fears for children's safety, of course, are very prevalent, and there is a tendency to overprotect and avoid risk, and it can diminish access to play. Parents are more and more encouraged to focus on academic achievement and learning. There's a recent survey that shows across the schools across Europe and the length of break times, how much it has changed from 1995 to today. And in the past 25 years, the break time of children in school aged 6 to 10 has decreased on a weekly basis by 45 minutes, and children aged 11 to 16 by 65 minutes. So this study also found that around 60% of primary and secondary schools that responded to the survey reported that children might miss a break or even a lunch break due to misbehavior or trying to catch up with their work. So I think it is important to call to action. And as adults, as lawyers, as parents, we should be concerned by the diminishing opportunities for play within the lives of children. We should challenge the approach that prioritizes the outcomes of play that adults find important over the enjoyment and the process of playing. And we should advocate for a rights-based approach to children's play. To be honest, the fact that we still have to advocate and talk about or justify play's existence in children's cognitive, physical, and social development seems incredible and appears to reflect an intransigence, even an ignorance on the part of policymakers and those who regulate policies. Play cannot be considered a luxury or a right which must be honored once all of the other rights have been honored. On the contrary, play is an essential integral component which reinforces the 4 principles of the CRC: non-discrimination, survival and development, ensuring the child's interest and participation. So once we look at the implementation of this right in different jurisdictions, we have to conclude that it is one of the least known and least recognized rights of childhood, and consequently it is one of the rights that is the most consistently ignored rights and undervalued and violated in today's world. So in my paper, where you will be able to read about this topic in a lot more detail, I'm going to explore the question whether it is possible to ascertain to which degree Article 31 of the Convention is applied from an international comparative legal perspective. So if the international community, via the Committee on the Rights of the Child, believed that it was necessary to give a stronger emphasis to this right, then we should ask whether the approval of General Comment number 17 has signaled a change in states' child policies. In other words, do the state parties now invest more in dedication and in effort to fostering and defending the child's right to play? How is it being exercised in different states? And are there reports or indicators proposed on the indicators proposed by the committee? And what measures are state parties taking to foster the child's play in the family, in school, and in social life? So it is a paper that examines, from a comparative perspective, the child's right to play across various countries before General Comment number 17 in 2013 and after its adoption. So while I want you to read my paper, of course, I think I'm not giving too much away with a few spoilers. And in very short conclusion, just saying that essentially, in short, General Comment number 17 has not led to a significant change in which state parties pay greater attention to the child's right to play. So the international scene tells us that there are some countries with good practices, such as Germany, Austria, Canada, Ireland, but the majority of the state parties still violate the obligation to fulfill Article 31. To make matters worse, there are states that openly recognize that they do not pay attention to this right because of their own lack of recognition for this need, like Ethiopia, for example. So the countries that do have policies that touch on the right to play primarily cite play areas or playgrounds. However, there are very few references to playtime or playmates or play materials, so play should be viewed holistically. Having the right spaces for it is just the beginning, of course, but it doesn't guarantee child play, which requires time and materials and playmates to reinforce the child's right to play. So one essential factor that cannot be ignored is that there are virtually no comments on laws and regulations that encourage, finance, or regulates the child's right to play. And a sad but a very interesting observation or proof of the forgotten nature of the child's right to play is that most countries are not even able to provide statistical data on it. When the state parties were asked to report on For example, the number or the percentage of children in extracurricular activities, or the number of playgrounds, and whether those playgrounds were in rural or urban areas. Despite the obligation to do this, most states were unable to provide statistical data. And I think this observation is crucial, because you cannot improve something if you are not able to measure it. So I think this is the start, of course. And even in legal circles, this right is very often forgotten. When I told my colleagues about this conference and they were asking me about what my topic was going to be, and I mentioned, a lot of them were confused, and some of them even asked me, the right to play, is that a thing? So I think it is time to emphasize how crucial it is to foster the right to play. Policies in favor of children in which play is ignored cannot and should not be developed. It is indeed possible to cite other priorities or urgencies, but it still makes no sense, because the ones who need to have play as a major ally to contribute to their development are the most disadvantaged children. The children who are the most vulnerable ones, the ones who live in poverty, the ones who grow up without parents, the ones who suffer from various kinds of exploitation, from violence, abuse, or mistreatment, and we have to protect these children. So in my paper, I offer some policy recommendations, because I believe that by managing to formulate a system of benchmarks and indicators to evaluate the recognition of the child's right to play, it will be possible to have some benchmarks or criteria to monitor compliance with this right, and to enable it to be evaluated and ensure that play is part of the objectives, goals, and strategies of the action plans of governments in favor of children. Through play, children prepare for the adult world. They practice their role of life even though they are already on the stage of life. Through play, children develop exactly those competencies that they will need in life to become successful adults or functioning adults. So our task is to ensure that all preconditions for children to develop into complete person, psychologically, morally, and physically as well. So therefore, one of our goals should be to educate about the importance of play and to ensure the total respect of the implementation of the child's right to play in practice. And I think that the world that understands the importance of right to play will be a much more vital, a healthier, a more alive world than a world without play. Children tell us most of what we need to know in order to help them grow and learn. And what we must do is to follow them where they lead us, to follow them where they go. And what we will find is very often that children play. And we can find out the way they play speaks volumes about who they are, how they feel, what they want to become, what they are afraid of. So I think it is really important to observe this. And in fact, if we see children that are not playing, usually we know that something is terribly amiss. So our role as adults, as lawyers, as policymakers, as parents, as carers of these children is to provide for their needs and respect their rights, including the incredibly important right to play. Thank you for your attention.
Very warm welcome to Commissioner, Professor, dear colleagues. I also believe that these 2 days are very inspiring. And so I would like to thank the organizers. And the 15 minutes are sufficient only to provide some excerpts, some fragments of thought. The ECHR what I would like to highlight only 3 articles, 8 11, 12 and 14, which in terms of adoption is also important, and the court also examines these. We also need to say that not only in terms of adoption, but in terms of the development of children's rights, the European Court of Human Rights did huge steps. I would only like to mention the visitation rights or decisions regarding illegal takeaway, and it proclaimed this indeed violates Article 8 of the Human Rights. Unfortunately, several decisions of the ECHR also condemned Hungary. Competing rights and interests among these, we can also find the supreme right of the child. This is also important in adoption cases, and I would like to speak about some cases. At the same time, I would also like to emphasize that the concept of the family is to be examined from case to case. In the practice of the ECHR as well, we can see lots of aspects apart from marriage. Also, what kind of blood relation there is, what kind of true practical collaboration there is, financial dependency, and as for adoption, according to the practice of the will of adoption, this can be considered a will to establish, to create a family, because by adoption we create a family, but the agreement does not mean that the person who adopts has a substantial right to adopt. In the very early decisions, the court also said, it also needs to be said that court is not substituting national competence, national authorities, but checks whether national interpretation and its effect is in harmony and or not practically with the agreement. Maybe I do not reveal any secret to the protector of children's rights that this is an important legal institution, because from this aspect of children's rights, adoption is one of the most exciting fields. It affects lots of fields, from constitutional to civil right, from the Act on the Protection of Children's Rights up to administrative law. Its regulation is not unified either in Europe, in the European Union, or in the countries of the Council of Europe. There are certain similarities, but there are no common denominators in several cases. The values and principles, however, are common, are the same, so this is very important. The aim of adoption is to settle the final destiny of the child, to provide family, to provide relatives, and in this aspect, it's not an institution of financial law, but of family law, and the child gets into a family via full adoption, so it leaves its blood relationship and integrates fully into its new family. There are countries where both are known. In France and in Italy, both partial and simple adoption exist, but the Hague International Adoption only accepts full adoption. When did the highest interest of the child appear in the law? In the 1960s, actually, and in the Children's Right Agreement and in the Hague Agreement, this is also present. But speaking of adoption, I would also like to emphasize that although previous documents also set up a ranking, that national adoption should be promoted, fostered first of all, but we also need to speak that the utmost interest of the child is to grow up in a family. And if this is not possible, the most important is to re-educate the child into its original family. So if the conditions exist, adoption can be carried out only if the child cannot be taken back into its family. The state has obligation in these terms to settle the family situation, to provide subsidy support. And I believe that the Children's Agreement slightly violates the right of the adopters because the primary function is making the true parents adequate. So this priority should not be missed when speaking of adoption. In 2008, the agreement of the Council of Europe was checked again, and Article 7, paragraph 1 and 2 is what I would like to highlight. Hungary signed this, did not ratify this. It is an exciting question. The adoption of same-sex couples. Different countries provide different answers. What tendency is typical? Well, we all know this. Yesterday we heard from the Secretary of State that women deliver babies at more or less at around the age of 29. Statistical data actually decreases, says that childbirth decreased by 5% and weddings by 10% in 2021. Hopefully this deficiency will not increase but will take a favorable turn. However, the traditional family type, along the traditional family type, other family types also appeared. And yesterday we also heard that 500,000 children grow up with a family consisting of one parent. And research also shows that there is mobility between family types, and that relationships are also fragile. This also applies for married couples and also for other kinds of stable union. Maybe we should ask the question, and I will ask it right here, in terms of relationship types, what is it that we consider to be a family, what belongs there, and what intentions does the state have, what aims does the state have, which forms does the state foster, promote, accept in terms of family types. Each state provides all different solutions. The Hungarian constitution says that the family is basic, but the Hungarian civil code protects a larger family type, also protects adoption, so also relationships that came about a different way. In most countries, that is, so this is the question that occurs. What is the family type that is supported by the state? The Hungarian regulation states clearly that only married couples may adopt, with some exceptions. Same-sex or different-sex couples cannot adopt children if they are not married, and there is a separate regulation for adoption in order to check the suitability of same-sex or different-sex couples. On the left-hand part of the slide, you can see the different regulations of the different countries. I would not go into details. And you can see what other kinds. I would only like to emphasize and mention Romania, which a couple of years ago took the decision that different sex couples, in the case of different sex couples, the relationship can develop. So if somebody educates such a child, an orphan child, for 5 years, then they can adopt this child. The specialist committee preparing the Hungarian Civil Code also came up with such a proposal to provide for a wider scope in terms of adoption, but this not came into force. And I also brought some different statistics, which also shows that the people suitable for adoption, 10% of which is a single parent, is also increasing. The number of children to be adopted is decreasing, although the rules for the child to be adopted are also changed. This is also shown by the 2012 statistics, but we can also see that most children are above the age of 10, and most such children are handicapped. So adoption from abroad will mean a home to them and will mean family to them. We can also state that both the CRC and the court also affects how a family law is shaped. So the court takes steps so that family law regulation changes one way in a good way, and obviously they have more freedom wherever there is no common denominator. Whenever the ECHR discusses a case, there is a comparative legal analysis that the court carries out and examines whether in the analysis of the state there is a common denominator or not. Obviously, the biggest deficiency is adoption as a single in the system of the different nation states, but similarly we can also see differences in terms of suitability, preparation, revoking parental consent, although this is not a lack of common denominators, but I would say that there are similarities, no such big differences.
Now, what the court investigates and checks, and I would like to mention some concrete cases. So these are the Articles 14 and 8. So the convention says, and also the court highlights that Art 8 does not guarantee the right to creating a family and to adopting, but it also says, so the court in this in connection to the interpretation of Article 8, that concerning contact to the right to keep in contact to other people belongs here. But as I do not have much more time, I just want to highlight a few decisions. So there is a case from Switzerland here. The request of adoption from a single parent, single mother was refused because of the huge age difference. So the applicant was 48 years old. The court was looking for the common denominator and stated that there is no big difference between the member states. So according to the main law in Hungary, also the age difference cannot be bigger than 40 years, and in the case of older children, 50. So, but in this case, the situation of the second child was also investigated, because with the second child, the dynamics of the family changes, and his or her situation has to be reinvestigated. And then concerning adoption, sexual orientation is also a topic to be checked. In this French case, and that you see the details on the slide, the French court said that the Article 8 and 14 were offended because the French law enables the adoption by single parents. And with other sexual, and if somebody has a different sexual orientation, only in this basis their adoption cannot be refused. In another French case, the court said that the French authority complied with Article 18 and 14 of the Convention when they refused adoption on the basis of a different sexual orientation of the applicant, because the interest of the child had priority. So in this regard, adoption can be limited. So the basis, the health of the child should have priority when making such decisions. And also in this case, the disadvantageous differentiation was so discrimination was also determined, that the discrimination was so unproportionality is always looked at, and discrimination. So again, here we do not have a common denominator when we look at the interpretation of the courts concerning applicants for adoption when they have different sexual orientation. So it's a very exciting issue. Two different opinions are connected to this decision, and one says that the French law was very strict, so the authorities were actually unable to really investigate real interests. So these are really interesting issues. There is a next case from Switzerland. There was an applicant. The partner wanted to adopt the ill and disabled child of one's partner was the subject for adoption, but it would only have been possible if the parental right of the mother would have not existed anymore. And then the court said that not only the biological relationship should be investigated, but also the bonding, the attachment. So if the child is in a family, then the law should enable this kind of bonding and attachment. So if the partner has been raising the other partner's orphan child for over 5 years, then adoption should be enabled for him or her. So, and the next case comes from Sweden, and just as a conclusion, if the parents' supervision right was investigated and checked in this case, well, the Hungarian legal legislation is absolutely compliant with the convention. So there are also cases of confidential adoption, secret adoption. In the case of the different adoptions, the national laws have to be regarded all the time, and there are of course also changes in them. In this case, this is a case from Germany. It's a case of open adoption. If there is an agreement between the adoptive parent and the biological parent, then visitation rights can remain, but these have to be documented. But in this case, there was just an oral agreement and not a written one, and this was the problem. So the German authorities said that with the adoption, all rights cease. But the mother should have been informed about this, that an oral agreement in itself is not valid, is not enough. A written one is definitely necessary. It is also important to us that there is a possibility for revoking a decision for 2 months. This is a case from France that you see here. So there is 2 months for revoking a decision. So this is the legislation. It's similar. So again, there is this 2 months interval in the case of open adoption. So kind of balance shall be established between the competitive parties. The common denominator was looked for. So according to the European Council, this interval is between 10 days and 3 months in the different member states after necessary information provided to the mother. And this is actually reassuring that the mother not only received information but also sample a letter should the mother decide not to want to give her child into adoption. And here a case concerning grandparents, a case from 2019 where the court said that automatically visitation rights from parents cannot be refused. However, according to Russian legislation, the grandparents have to ask and request such right for visitation, especially concerning if the subjects are adopted orphan children. So this is how this connects to Article 8 of the Convention. So what can be a summary of all this? Well, maybe that Hungary adopted this convention in 1993, so this can be referred to. Behind all laws, there are the norms, which are also human rights, fundamental rights, moral rights, securing dignity, human dignity, and what shall be highlighted that as such decisions provide guidelines to solve our cases before national courts so that the involvement of Strasbourg becomes unnecessary. Thank you for your attention.
Okay, good afternoon, ladies and gentlemen, and it's a great pleasure to participate in this interesting conference. I would like to express my gratitude for the organizers for prepare such an inspiring event and for the invitation and ability to share some of my thoughts dedicated to children's rights and alternative care. Why I decided to choose this topic to talk about? Probably because there is 1.5 million children in the countries of the Council of Europe that are the children who are put into some kind of form of alternative care, so with relatives in foster care or other family-like settings, but also they are in the state's institutions. And the element which is very, very important is that in the institutions we have mostly children with disabilities. There is a lack of data dedicated to the situations like that, but regarding to, for example, Serbian government analysis from 2019, more than 70% of children in alternative care, institutional alternative care, were children with at least one form of disability. And the second reason for analyzing the standards dedicated to the alternative care is that last year on the United Nations level, we have the Day of General Discussion dedicated to the rights of the child, and the topic of the Day of the General Discussion were the alternative care. When we look at the standards of the alternative care, we can find them on the two levels, the universal one and the regional standards. As to universal standards, we need to underline the Convention of the Rights of the Child, and there are two articles dedicated to this regulation. So the Article 3, which is kind of leading article because it's the rule of interpretation of the convention. So it's the article that tell us to understand the convention and taking all the actions dedicated to children in their best interest. And the Article 20, which is dedicated to the special protection and assistance which is necessary to be provided by the states to those children who are deprived temporarily or permanently of their family environment. At the regional level, we have the European Convention of Human Rights and Fundamental Freedoms. And as you are aware, this is the document which is very general. So we do not have dedicated regulations specifically dedicated to the alternative care, or even there are not so many dedicated to children as such, but the European Convention is the document that look at the children as we all should, like the children on human rights, just the small one, but the human rights. So they have right to enjoy the right to respect for family and private life, which is guaranteed in the Article 8. Another element which is also important because it includes very inspiring practice is the European Social Chart which in revised version includes Article 17, which is the right of the child and young person to social and legal economical protection. And of course, because all of the members of the Council of Europe are also the members of the European Union, we can look at the Charter of Fundamental Rights of the European Union, and there are 2 articles dedicated to children in the field of in the light of alternative care, which is the Article 7 that protects family life, and Article 24, the rights of the child. Of course, there are also some other so-called hard standards that might be used when we are talking about alternative care and when we are searching protection from the rights of the child. You have here the Convention on the Rights of Persons with Disabilities, the Convention for the Prevention of Torture and Inhuman and Degrading Treatment or Punishment, the European Convention of the Exercise of Children's Rights, Contract Convention, Adoption Convention, and Convention on the Protection of Children Against Sexual and Exploitation and Sexual Abuse. And these are so-called hard standards, need to be interpreted, need to be seen also with so-called soft law regulations. And when we will look at the soft law regulations, we are able to find at least 3 of fields that we can identify those regulations. The first is the resolution adopted by the General Assembly, so we are on the universal level, and these are the guidelines for the alternative care of children. And then we have the level of the Council of Europe, and we have here some recommendations and resolutions. And when we look at the European Union, we have Fundamental Rights Agency, and there is a handbook of European law relating to the rights of the child. Fortunately, the way that European Union look at the rights of the child is mostly connected with the view of the Council of Europe, because in this handbook you are able to find the regulations that are connected with the Council of Europe practice and of course the juridical practice of European Court of Human Rights. There are also some other soft law documents. I will not analyze them, but I just want you to be aware that they might be in some circumstances necessary to analyze when we are talking about the children in alternative care and about how to protect them in the best way. I just want to focus on the 3 of those soft law. And the first is the resolution that was adopted by the General Assembly. And this resolution underlined one very important thing, because this thing is very common for the documents connected with the alternative care of children. The first element is the child and the family, and underlining that the family is a fundamental group of the society and the natural environment for children to grow and children to develop. And all the decisions must be made by case, and it is necessary to avoid discrimination of children. And it doesn't mean, and it the elements of the discrimination need to be avoided on any level. So it doesn't matter if the child is poor or not, the ethnicity, the religion, the sex, the mental or physical disability, and for example, if the child is born out of a wedlock or not. This resolution underlines the importance of alternative care, and if it is necessary to put a child in an alternative care institution, it is important to choose as close as it possible to his or her habitual place of residence. And removal of children from family should be the last step, last thing that we do. First, we need to do everything to prevent the alternative care. So we need to support the family, social needs, and create the legal solutions that will help develop a family in a proper way. And if it will be necessary to separate a family, the institutions need to do everything to support the reintegration. The resolution also underlines the necessary standard of the institutional care facilities, so the carefulness, professionalism, ensuring the contacts, and high standards of the other implementation of the standard that are included in the resolution. When we look at the resolution that were created on the ground of the Council of Europe, we are able to find some general principles which are quite similar to the universal solutions, because the need for the placements should be avoided as far as possible. So the first is to prevent, to help families, to support family, and assist family on any fields that are necessary. And if not, the placement of the children in the institutional care needs to be in a proper way, because it's always a huge problem for a child. It's something that is very deeply connected with child's feeling. And of course, it is underlined that the aspect of management are also very important. So promoting the foster care, except, for example, institutional care. In the recommendation from 2011, we are able to find that there are some fundamental principles with the best interest of the child as the first one, but also the child's right to participation and protection. The child's right to participation in the procedure connected with the social service and the friendly environment is connected with the Article 12 of the Convention of the Rights of the Child, which allowed the children to express their point of view. And of course, it is also necessary from the point of view of the recommendations that the children in foster care should have their situation regularly reviewed, and some recommendation dedicated to the deinstitutionalization. So smaller groups to like foster care, like relatives are better environment for children than the institution. And when we look at the another recommendation, we can find another similar element that before, so the family as a natural environment for growth and well-being, and the exception for placement children in other environment than the family one. And there are also some specific rights for children living in the residential institutions, especially the need to ensure the respect for the basic principles and fundamental rights of the child, including the regular contact with the relatives. And when we look at the handbook of the European law, they are just general principles that are similar. So one of them is saying that alternative care should be temporary, that international law confirms that the family-based care is the one that should be preferred, and that the children have the right to information and to express their view with respect. And this is how the standards looks like. And it's quite short, but they look quite, we can say, similar. We can say that they are quite well prepared. Unfortunately, practice shows us that there are a lot of problems dedicated to the children that are placed in the institutional care. I would like to shortly examine 4 cases. The first case is very known case. It's Nancheva and others against Bulgaria. So it's the case dedicated to the examination of the situations of the death of 15 children of institutional care that were in very difficult conditions because of the economical crisis in Bulgaria, and because of the fail of the lack of medicines, the lack of regular visits, the way to the hospital, the institution that the children were placed were 40 kilometers from the nearest hospital, the cold also, and the hunger. 15 of those children unfortunately died. And regarding the European Court of Human Rights, the authorities failed their obligation, also their obligations when it came to the investigation procedure. Another case is the Center for Legal Resources on behalf of an Indian company against Romania. It's a very important case from my point of view because it's the case that allowed someone who will not be able to speak in their own voice to have his right fulfilled after his death, but it's a kind of symbol, and I think it's a very important one. In this situation, a boy who was a young Roma died in a state institution. He was a person with a disability. He was also high diagnosis. And in absence of close relatives, one of the NGO decided to start a case before the European Court of Human Rights. And what was very important, the Grand Chamber of the Court decided that this NGO was entitled to represent the descent complaint. And the European Court also found a violation of the Article 2, so the article dedicated to the right to live, because this boy when he was staying in the institution, there was no heating, there was no bedding or clothing, and there was no support, especially that he was high diagnosis and he needs some special medicine. And this was a case that was very binding because it was showing that the European Court of Human Rights, seeing people even and want to find justice even if they are dead, and even if there is no any other relatives who would like to who want to speak with their voices. Unfortunately, in 2016 there was another case when the association tried to support a complaint before the European Court of Human Rights, and this time the European Court found this case inadmissible because it was saying that the association, the Bulgarian Helsinki Committee, cannot represent those 2 girls whose death was so problematic because they didn't interest in those girls when they were living. In the situations, in the case in Romania, this Central for Legal Resources, they were in contact with the boy when he was alive. But in these situations, in a Bulgarian case, the Helsinki Committee received the information about serious abuses from the television program and tried to start a case. Unfortunately, the European Court of Human Rights said, no, you were not supporting those girls before, and you are not relative, you are just, you are the non-governmental organization, so you are not allowed. And the death of those 2 girls was very problematic because they died as a result of neglect, and very serious. One died because there was a lack of food for her, and the second died and this is probably you're wondering why I put so many strange things on my presentation. Those things were found in the stomach of this girl. So she ate all those things, and that's why she became ill, and that's why she died. So no one in this institution find out that she ate so many things. I may understand some kind of paper and maybe small stone, but we have the number and the things that were found in the stomach of this girl. And I think that there's one more problematic element that the European Court said, that those girls have relatives because they both have mothers, but those mothers were never interested in them, and those mothers were never visited them, and those mothers didn't want to start any case because they didn't care about those girls. And the only possibility that the examination of the situation and finding or not violation of human rights was unfortunately by the European Court skipped because they didn't allow. It's something completely different that we have on the European Committee of Social Rights, because in the European Committee of Social Rights we have the mechanism of this collective complaints and the non-governmental organizations are able to start cases in the name of, and there are a lot of examples when they are starting the cases in the name of children. And because I do not want to say that always the state and the state authorities behave in an improper way. There is one case against Romania showing that in the situation where social services finding out that there are some serious problems with the family and how the family should behave, because the children in this case did not attend school, they were not registered with a doctor, they're living in a very poor condition, and their parents' situations, financial situations was that bad that it not provide the children safety and development opportunities. So the court decided that temporary placement to the children in the institutional care is something that the authorities should do in the situations like that. But it is very important that this is the temporary placement. So the Romanian authorities after that decided to do everything to Yes, this is just the last. This is just the last one. Okay, the conclusions. So coming to the conclusions, the first element is the leading role of the family. So supporting the family is something that is very important. The need of the idea institutionalization. This is something that was put it in the strategy for the rights of the child for 2022 and 2027. We need to also look for the soft law standards because they give us a wider perspective how the alternative care should look like. And we should find some better legislation to protect the children's rights because before the European Court of Human Rights, no governmental organizations are not able to act, but maybe the Ombudsman for children's rights. And we need to be aware of the fact that the problems with the institutional care will be growing because now we have new challenges, we have new problems like the war in Ukraine, like COVID, like economic crisis. So unfortunately, probably in future, we will have another cases before European Court. And what we should do, and it was saying during this conference, during one speech, is that it's the best that the best things is to take care about children's rights at the lowest level. So I think that we all should look around, and maybe it will help in the future. Thank you very much for your kind attention.